Hi, this is Josh Nelson with Nelson Elder Care Law. We're having Live with the Lawyer every Wednesday at 3 p.m. And I appreciate you joining me today. What we're going to talk about is a question that I get asked quite frequently, which is, do I need a will? Do I need a trust? What are the real differences between the two? And how do I decide which one's right for me? We're going to go through that and much more today on Live with the Lawyer. Again, I'm Josh Nelson from Nelson Elder Care Law, where we help you protect yourselves from the curveballs of life, making sure that you have the money that you need, as well as the autonomy as you age. Often whenever people first come into my office, one of the things that they're just surprised by is that there's so many options with how you structure your estate plan. At Nelson Elder Care Law, we really pride ourselves on getting to know you and taking an individualized approach. One of the things that we're going to focus on is whether or not you start with what we call a will-based plan, a trust-based plan, or an asset protection-based plan. Out of these three options, most people, whenever they first come in, are thinking that they just need a will. We've spent our whole lives being told that we need a will as we turn into adults. Often, that's a good move. If you don't have a will, the state has a plan for you. This is what's called passing intestacy. That means that if I pass and I'm married, my wife will get a portion of my assets and my children will get another portion. That's not what many married couples want. And so instead, they create a will. Often these are called I love you wills. What this says is that if I pass, everything will go to my spouse. And if my spouse is no longer alive, then it goes to my kids. This is the most popular type of will. You can also add things in there like who gets what stuff or who gets different percentages. The one thing to always remember out of a will, though, is that in the state of Georgia, it only controls what goes through probate. So if I have a joint account with one of my children, that's not going to be controlled by the will. If I have life insurance proceeds, I need to change the actual beneficiary designations on them, not just my will itself, unless those designations say to my estate. So why would somebody want more than just that? It sounds like you have a lot of control with a will, which is true, but it sends your family through a process called probate. There's a specific court in each county called the probate court. And what their role is to transfer assets from somebody who passed to their creditors first and then to their heirs. You'll notice there that the creditors generally come before the heirs. And that's why a lot of people get worried. The process is not designed just to give things to your wife and children. It's actually to make sure that your creditors are made whole before they get things transferred to your heirs. The process takes quite a while because we have to give notice to those creditors of 120 days. The whole process often takes in excess of 6 to 9 months, and depending on your county, such as Fulton, can take over a year. That's kind of crazy whenever you think about some of the alternatives. Remember that if I just had a joint bank account, whenever I pass, the joint owner of that account, whether it be my spouse or a child, can walk in and get access to those funds as soon as they have a death certificate. That usually only takes about a week or two. What can we not put those beneficiaries on in order to skip probate though? Land, real estate, sometimes business interests. Without a proper plan that encompasses all of your things and your assets, you might end up still going through probate. And that's why it's a good thing to have a will. Often, whenever I work with families that have land or have more complicated structures in their business, we'll start talking about trusts. There's two main types of trusts. The first type of trust is really designed to be able to give things to heirs over time without involving the courts. And another type of trust we call asset protection trust is designed to keep creditors from gaining access to your assets. Whenever we start talking about the big advantage of either trust over a will, it's going to be less complexity, less focusing with the courts, and one of the things that a trust does that a will doesn't do very well at all is have triggers in it on when beneficiaries get things. So maybe you have grandchildren that you don't want to receive the money until they're over 18 or over 25, or in some cases even 65. You can do that with a trust. The other big thing is having the land pass without having to go through the courts. So remember that if you use a will and you actually have a home that's just in your name, whenever you pass, that home has to go through the probate process in order to have a new deed done, called an executor's deed, that actually transfers the assets to your heirs. A lot of times we work very hard our entire lives to be able to pay off our home, and it would be quite the shame if somebody came in and saw the opportunity to profit on this process, and so they did so by making an offer to your heirs that's below market value. This is a common theme of some of those late night get-rich-quick schemes. The other big thing that we focus on with a trust is that a trust can help protect you even if you're alive. Whether it be an asset protection trust or what we just call a living trust, if you lose capacity, you can have tools like a power of attorney, but sometimes those can be hard to use. Even if you have a very strong power of attorney and it's not filed in advance of you getting incapacitated, or if the amount of money that somebody's trying to deal with is in excess of $100,000, they'll get some pushback from the banks. That's probably a good thing, because we don't want somebody just to be able to walk in with a piece of paper and walk out with your money. But in a crisis situation or a stressful situation where somebody's trying to be your caregiver, this can overwhelm them. An advantage of a trust, whether an asset protection trust or a living trust, is that at the point that it was put into the trust, what's called funded, your trustee or your successor trustee, if you were the original trustee, can actually go handle those funds for you, make sure that what you worked so hard for your whole life is actually being used for your care without the pushback of the banks. Whenever we move from that tier of a living trust into an asset protection trust, the big advantage is the order in which people get paid. Even with a living trust, the proper way to administer it is to pay creditors first. With an asset protection trust, though, a lot of times you'll be able to make it so that the personal creditors of the grantor, or the person that created the trust, if they personally owe money that they started to owe after the trust was created, oftentimes those debts will go unpaid. And what you've been able to preserve is what you've worked so hard for going to your family. This is pretty cool. It's an advanced planning strategy, but it is something that you need some good guidance for, and it doesn't work in all situations. None of these options are necessarily the right option for you if you haven't sat down and thought about the pros and cons. Some people that don't have land will still need a trust. Some people that do have land will need no more than a will. At the end of the day, a lot of it comes down into tax planning, family dynamics planning, and an overall ease of strategy for you. If you'd like to come in and sit down and member my legal team, really get a good strategy session going for you and your loved ones, we'll do that complimentary for you. You just give us a call, 678-250-9355, or feel free to shoot us a message at Nelson Eldercare Law, and we'll be glad to get you on the books. Thanks so much for joining us with Live with a Lawyer. Again, I'm Josh Nelson with Nelson Eldercare Law. Have a great day.